Hello, my name is Mark Monlux, and this is another episode of Law and Artist. I'm a freelance illustrator, and I often have questions that I share with my friend Daniel Abraham.
I'm Daniel Abraham. I'm an attorney, former freelance illustrator, and most of my clients are involved in the arts one way or another. And it's a pleasure to be here as always.
First, a disclaimer. Law and Artist discusses general principles of law in response to issues of concern to the illustration community. Nothing in this video or in the Law and Artist comments should be construed or be substituted for advice of counsel regarding the specific facts and circumstances of an individual case. Laws and their interpretation differ from jurisdiction to jurisdiction. Legal advice addressing a specific situation should be sought from an attorney duly licensed in the appropriate jurisdiction. Today's topic is derivatives, and here's what happens for me, Daniel. I often get calls from other artists and they say, Mark, I'm doing this great illustration, it looks fantastic, but the photograph that I'm using is not my own. What are the, is it okay? How much do I have to change it in order for it to be my own? And this can cause a lot of problems.
Absolutely, absolutely. The worst thing is to go ahead and do something without permission, especially under the what I call street copyright view, that if you change something X%, that it somehow makes it all right. This is something I don't know where it comes from. I don't know how you're able to actually do a percentage. Now, here's an perfect example. Everyone knows the Obama poster by Shepard Fairey and knows that he got into an immense amount of legal trouble about his use of this photograph. It's an interesting mixture of trouble that he got into because he used the photograph without permission. The photo agency that he got it from claimed that they had the rights. The photographer said the photo agency didn't have the rights. And then Fairey lied to the court when they were adjudicating this about which photograph he had done. Big bunch of hassle. He could have simply asked for permission, obtained a license, and he would have been in much better position.
I think I can speak to where people get the misconception of how they can change an illustration. The coat of arms system that knights used to use has a system where in a heraldry device has to have two devices different than the previous heraldry device in order to be accepted as an award of arms.
As in a new coat of arms, okay.
So that might be where it originally come from, but that's strictly a theory on my part.
Well, it reminds me of some of the strange legends we learned in high school about how you could have sex and not get pregnant, but we won't go there.
So let's talk about what we can use. If you are using a photo, you can use it as a reference, right? But you can't copy it.
You can't copy it directly, and you've got to be, basically, if somebody can identify the original photograph, you've used too much of it. You can use it as a guide, but that's about it.
And asking for permission, really, most people are willing to give you either a very minimal amount for a license for your work, or they'll just flat out give you permission to use your work and create a derivative with it.
That is correct. That is correct. We can get into this in greater length in a follow-up broadcast. If that is, how are we doing for time?
We are at 4 minutes and 25 seconds. So why don't we wrap this one up and we'll do another follow-up video that discusses more derivatives.
Sounds good to me.